Let's talk about the Supreme Court's decision to uphold South Carolina's ban on Medicaid funding for Planned Parenthood clinics. This was a 6-3 decision along ideological lines, with the super conservative majority of the court all voting to uphold the ban. This was not a case about abortion rights. The use of federal funds to pay for abortion services was already banned in the United States. So this case was about whether South Carolina can exclude Planned Parenthood from Medicaid funding for any service, including birth control services, including primary health care services, including maternal health services. Federal Medicaid law guarantees that Medicaid patients have the ability to choose their doctor, or in the words of the statute exactly, they're entitled to care from any qualified and willing provider. But South Carolina passed a law excluding Planned Parenthood from any Medicaid funding because they also provide abortion services. And they argue they could disqualify Medicaid providers for any reason that state law allows, which is directly contrary to the way federal Medicaid law is written. So a patient in South Carolina who uses Planned Parenthood for their health care services sued, saying that the state of South Carolina's ban on Medicaid funding for Planned Parenthood violated her right to choose any qualified and willing provider. This case went up through the court system, and the ban was overturned at every level till it got to the Supreme Court. Gorsuch wrote the majority opinion, and he said, in any case where conditions are put on how federal money is spent, Congress's statute must clearly and unambiguously authorize the right to sue for individuals. Justice Ketanji Brown Jackson, writing the dissenting opinion, that the statute could not be more clear in terms of its intent. So what this means in South Carolina is, in a state that already has a shortage of primary care providers, they may lose 2 clinics which serve a significant number of low-income women. It all begs the question, when there is a federal law, in this case the Medicaid law, and a state chooses not to follow federal law, if the recent ruling is to set a precedent, then individuals would have no recourse. They couldn't sue to force the state to follow federal law. It would have to be the Department of Justice that would have to force the state to follow the federal law, which in this particular case, with Pam Bondi being the Attorney General, is clearly not going to happen because of this ideological divide. And it seems like a dangerous precedent to set. If there is a federal law and a state chooses not to obey it, but the Attorney General of the same party affiliation that is the majority in that particular state, is there any way to force a state to then follow the law?